Hello, friends, and welcome to today's episode, a short episode, Legal Talkies with Abhijit. I'm your host, Abhijit Negi, advocate practicing in the Delhi High Court and the Delhi District Courts. Today, I wish to speak about an important topic that concerns only a very few, select few of us, fortunately. Well, the topic is mercy petition. Today, I wish to address about Article 72 of the Indian Constitution, specifically which speaks about the mercy petition. Now, we all know that uh, in criminal cases mostly, or rather exclusively in the domain of criminal cases, there is a set of criminal justice system process appeal process that after the conviction by trial court, the judgment and order of conviction rather in cases of death sentences is confirmed by the high court, concerned jurisdictional high court of the state. And from there, if it is upheld, there is an option available with the convict to further appeal. The accused person who has been convicted can appeal from the even the High Court judgment which has upheld his conviction to the Supreme Court. Now, if the Supreme Court also holds the same that yes, the trial court decision or judgment is correct, and it upholds the death penalty awarded to a convict in case of heinous offenses such as causing murder as well as causing rape and murder. So, in that case, what is to be done? The final safety mechanism or the safety valve, as per the scheme of the Indian Constitution, lies in Article 72 of the Indian Constitution, which deals with the powers of the president to hear, in common parlance, what is known as mercy petitions. I'll just briefly read the provision so that you can, make a sense of it, rather just the heading of it. It says the power of the president to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. So, as we can make out from the usage of certain words such as remit, suspend, commute, that it is actually operating in the realm of criminal justice system or criminal laws and not in case of the civil punishments. Because punishment presupposes an offense, and an offense is usually a criminal offense. So, with that distinction in mind, I just wish to also stipulate or rather lay down the three situations in which the mercy petition or the powers under 72 of the Constitution uh, can be invoked, or rather, there is a remedy that the final remedy that lies with the President of India, which is exercise the power exercised by the President in mercy petition. So the first would be in all cases where the punishment or sentence is by a court martial. And this is of course adverting to the armed forces, and within its ambit comes the paramilitary forces as well. The armed forces, if they convict a person in a court martial, the final remedy would lie with the president. Second, and interestingly, is in all cases where the punishment or sentence is for an offense against any law relating to a matter to which the executive power of the union extends. That is the union government or the central government. So that is there. And third is in all cases where the sentence is a sentence of death. So by the very wording of this section, we know that it is now confining itself in matters of the criminal law only. And often we see that this is the last ditch effort, as you would recall some landmark cases such as that of Afsal Guru, Ajmal Kasab. These were the terrorist cases who were convicted terrorists, not only convicted by the special courts dealing with such heinous and dastardly terrorist attacks, but they were subsequently confirmed by all the appellate courts, that is the High Court as well as the Supreme Court. So in this case, the lawyers were left with only one remedy, that is to go for the mercy petition, that is to invoke the power under Article 72 of the Indian Constitution. Now, a very important point that needs to be remembered in this Article 72 is that the President is acting on the aid and advice of the Council of Ministers. That is his Council of Ministers, that is He is acting on the aid and advice of the Council of Ministers, that is the central government, and he or she is not exercising the power on his or her whim. That is, there is a method, that there is a process that is followed. It is not a personal discretion to grant pardon that is given to the president under this particular article under the Indian Constitution. I hope today's session, though short, was informative, and I was able to shed some light on a very important constitutional provision of the Indian Constitution. Look forward to hearing back from you and hearing about your comments and your inputs regarding the same. Thank you.